This is the Missouri Medical Marijuana Update for January 20th, 2019. Now, this bill would require the Department of Health and Senior Services to seek expungement for any marijuana-related misdemeanors from the record of a new medical marijuana card holder. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Today, we're going to talk about a few important issues coming up. First, I'd like to discuss some of the frequently asked questions that we've received in my office. Can an employer fire me for medical marijuana use when I'm not working? Unfortunately, the answer to that is yes. In Missouri, we are an at-will employment state. While the amendment specifically denies authorization to the employee to bring a lawsuit against the employer for wrongful discharge, discrimination, or some other cause for being under the influence of marijuana or attempting to work under the influence of marijuana. The issue of termination for off-duty use of medical marijuana is an open question. So the short answer is yes, they can terminate you, they can fire you for medical marijuana, because they can fire you for anything. The supervisor doesn't like your hair that day, he can be fired in the state of Missouri. However, the longer answer is, can you do anything about it? Okay, and there may be recourse. Because medical marijuana addresses a medical condition, there might be recourse under Missouri law. However, we don't know yet how the courts are going to rule now that we have an amendment protecting medical marijuana in the state of Missouri. You would not be able to achieve any kind of recourse under federal law because marijuana remains illegal federal. Now, will my prior convictions be expunged when I get a medical marijuana card? No, they won't. However, there is a bill currently proposed and pending within the legislature, two actually, that will expunge certain convictions. And I'll do more on that here in just a minute with the legislative update. Now, the next frequently asked question is, I've heard I can't be involved with a dispensary if I have a criminal conviction on my record. Is this true? No, not really. No facility shall have as an officer, director, board member, manager, or employee any individual with a disqualifying felony offense. Disqualifying felony offense. Now, a disqualifying felony offense is defined as a violation of and a conviction or a plea of guilty to state or federal law that is or would have been a felony under Missouri law, regardless of the sentence imposed, unless the department determines that A, the person's conviction was for the medical use of marijuana or assisting in the medical use of marijuana, or B, the person's conviction was for a nonviolent crime for which he or she was not incarcerated and that is more than 5 years old, and C, more than 5 years have passed since the person was released from parole or probation, and he or she has not been convicted of any subsequent criminal offenses. Basically, this means that you can't have a recent felony history. How the department scores you on character in point number 1 of the scoring criteria, however, that's a different story. One of my concerns is that while there may be no hard line disqualification for a misdemeanor offender or for an old felony offender, but it's possible that people with conviction histories are going to find themselves at the bottom of the scoring criteria and the bottom of the acceptance scores as a result, which could turn into a de facto denial. I expect that there's going to be litigation on that in the future. Now, this is a big one. We've heard this. I'm sure a lot of you have seen discussions on Facebook or on Reddit or other places. Frankly, is the license system just a scam to make out-of-state investors rich? The answer is no, it isn't. There are a lot of people that are going to get rich during medical marijuana in Missouri. A lot of people. But all licensed facilities, or all facility license, I should say, shall be majority owned by natural persons who have been citizens of the state of Missouri for at least 1 year prior to application. All license holders shall be natural persons who have resided in the state of Missouri for at least 1 year prior to their application. That means that every business, every entity in the state of Missouri that's going to be running a cultivation, a dispensary, testing facility, or a manufacturing facility, every one of them will be majority owned by a Missouri resident. Now, entities from outside the state can own a minority stake in those businesses. However, what we're looking at right now is whether or not a license holder can then hire a company to produce or operate the facility for them as a sub-licensee or a contract entity. And I think that may well be allowed. It's really going to come down to how the regulations are promulgated this spring. So the actual license holder and the entity that holds the license has to be Missouri owned by 51% or more. So if you form a corporation, as I've discussed with people in the past, to pool resources, 51% of that corporation has to be owned by Missouri residents. Now, there are ways to handle that and to manage things as far as preference in voting stock or non-voting shares. That can all be worked out. But 51% of the ownership must be vested in a Missouri resident. Now, so those are some of the frequently asked questions that we've had. Now let's talk, because the legislative environment right now is phenomenal. We've got a lot of things going on. Now there are a number of drug-related bills that are before the state legislature in the House or the Senate, but I'd like to talk first about Senate Bill number 2. Now this was proposed by Kansas City Democrat Shalon Curris. Now this would require state government to give a 10% scoring bonus when evaluating license applications from companies owned by women or minorities. The bill will also require state government to take into consideration, policies by local governments, local municipalities that promote women and minority businesses. First, my thoughts on this are this adds criteria to the 10 listed criteria, and the amendment restricts consideration to those 10 criteria. So I think that this is going to present a layer that is not constitutional and would not be allowed. So if this were to pass, I expect it will most certainly be challenged in court, and that challenge could actually result in a delay of the implementation of licensing for everyone, because they're not going to know how to value this person over this person and evaluate those scores. So that bill is dangerous, scary dangerous. And I do have to say that I also understand the historic disproportionate representation of minorities as it relates to drug arrests and convictions. I mean, that's clear, and the statistics are clear. There's no question about it. But this bill is either blatant pandering or an attempt to derail medical marijuana licensing in Missouri. And, write your senator, write your state rep, and definitely oppose it. House Bill 440 is essentially the same bill. This is proposed by Kansas City Democrat Barbara Washington, and it has the same flaws as Senate Bill 2. Definitely should still be opposed. Now, then we get into a straight legalization bill, which I think is phenomenal. This one is proposed by also a Kansas City Democrat, Brandon Ellington, that would like to legalize marijuana for adults over the age of 21. Now, this is House Bill number 157. Under this bill, adults would be able to sell and transport up to 2 ounces of marijuana. They would be able to have up to 6 plants, 3 of which can be mature flowering ones. The bill will require that the plants be grown indoors, and it bars the sale of marijuana plants. Driving, also bars driving under the influence of marijuana. I'm not sure why they needed to do that. Driving under the influence of marijuana was currently illegal and damn hard to prove. If you are charged with driving while intoxicated, DUID, drug, marijuana, visit an attorney, because it's very, very difficult to prove contemporaneous intoxication by marijuana. They can show that you have smoked marijuana at some time in the past, but they can't show a level of intoxication for that time. Definitely talk to an attorney if you have that charge. I also expect that we'll get some development. They're going to have to come up with something. There'll be some kind of machine like a breathalyzer or something like that that they're going to use to test for this, but we're not there yet. So regarding 157, landlords are going to be able to prohibit marijuana growing, and employers are going to be able to forbid employees that smoke weed. That said, this bill or a variation of this bill is extremely likely to pass within the next 18 months. As we go on in the medical marijuana licensing schemes, and we see how much money is rolling into Department of Health and Senior Services, and we look at the sales tax revenue that's going to roll into veterans programs, and we're going to do another video on just those in the future, but that money that's going to roll in is massive. And I've said it before, I'm going to say it again, the state legislature hates it when there's a big pool of money that they can't touch. They want to have control. They want to get that money in the state revenue so that they can use it in regards to the Hancock Amendment. If you don't know what that is, look it up. We can talk about it another time, but I believe that full recreational legalization is probably within 18 months coming from the legislature so that they can attack the tax money. Now, regarding past criminal charges for possession of marijuana, there are two bills. They are both excellent, and I'd like to address first House Bill number 341, House Bill 341 from a Republican, Ron Hicks. Now, this bill would require the Department of Health and Senior Services to seek expungement for any marijuana-related misdemeanors from the record of a new medical marijuana card holder. So think about that for a second. This will require the state to pay to expunge your record of any marijuana-related misdemeanors. I would assume that would be possession of marijuana, D or A misdemeanors, or it may also be possession of paraphernalia as related to marijuana. So that could be a phenomenal thing. The bill will authorize the expungement of misdemeanor and municipal convictions, makes DHSS pay for it, and this is unlikely to pass. I don't see this passing, and I don't see it being signed by the governor. But damn, I like it. Write your representatives, write your state senators, see what you can do. Support House Bill 341. We definitely deserve that. Now, the next one is House Bill 292, and this is from Kansas City Democrat Barbara Washington. This is also an excellent bill and one worthy of being supported. First, this requires the courts to expunge marijuana convictions for 35 grams or less entered between the dates of December 31st, 1997 and August 28th of 2019. Those convictions will be expunged. So we'll be able to take it up and say, hey, it's a marijuana conviction, needs to be expunged. The court will sign off on it. It's going to come off your record. It should no longer impact your student loans. This is a good thing. Now, the bill also proposes that any convictions after August 29th of 2019 would be immediately expunged at the time of conviction. It's a really, really unique way to circumvent the criminal code, and makes it rather pointless to charge people for possession of a plant. You know, again, I like this. This is a good approach. It has no chance of passing. But these two proposals, one from a Democrat and one from a Republican, show that the state is moving towards the idea of one, full legalization, and two, expunging the silly misdemeanor, possibly even felony marijuana arrests that are plaguing so many people in our state. If we eliminate the marijuana convictions and we eliminate the marijuana charges, we eliminate a large part of the criminal docket. And we can lighten the load on our prisons, and this is a good thing. So please, write your state reps, write your state senators, support House Bill 292 and House Bill 341. Show up for any hearings if they're held. Even if you're not going to speak, show up and support. Hell, march on the Capitol and support if you need to. But those two bills need to be supported, and there needs to be an obvious visual show of support for them. That is the Missouri Medical Marijuana Update for January 20th, 2019. If you enjoy seeing this content, please like and subscribe and hit the alert button so that you'll get notified when we have something new. Thank you.